Uh, so I'll just do a brief introduction, and then we are going to be delving into a simplistic view of how law interacts with photography, because it's a very vast subject, and it's going to be very difficult to capture everything, but we are trying to keep it as interactive as possible. So we are going to leave a lot of time actually for receiving your questions, and we have a panel over here which will try and answer the questions and situations that you faced. So my name is Abhinav Sanghi. I am a qualified lawyer to practice in India and the state of New York. I completed a master's from Columbia University, and thereafter I took a sabbatical to pursue photography. I went to formally study it at the International Center of Photography in the documentary photography and photojournalism program, and I've recently moved back to Delhi. I have with me Apar Gupta. He's a qualified lawyer to practice in India. He completed his master's also from Columbia Law School from New York, and is a partner at Advani and Company. As a litigator, his practice is concentrated in civil and commercial disputes, which include arbitrations. A majority of his representations are for clients in the media and the telecommunications industry. He's authored a book on information technology, which has been published by LexisNexis, and he's a regular columnist for the Indian Express. There we have Arundhati Karju. She's a criminal lawyer practicing in Delhi. She graduated from the coveted National Law School of India, University, Bangalore. She specializes in white-collar crimes, and in particular for CBI trials. We have Sefi Burdison. Sefi is an Israeli-born photographer who has lived and worked in India since 2002. Previously a commercial photographer and the president of the Professional Photographers Association in Israel. His work in India revolves mainly around travel and culture, and he balances that out with photojournalism. He's an author of a blog called Photowala, and is the owner of the Digital Nomad, organizing workshops and photographic expeditions in India. Sefi has been active in drawing photographers' awareness to copyright and moral rights, and is now embroiled in a major copyright violation case in the Delhi High Court. Then we have Ishan Tankha. Ishan is a Delhi-based photojournalist whose work has been featured in a number of publications, including South China, Morning Post, Le Monde, India Today, Guardian, BBC, Open Magazine. He graduated with a bachelor's degree in history in 2001, and is currently the photo editor for Tehelka. So without further ado, we were supposed to have a bit of a slide, but because of technical things, I had like the structure laid out, but it's no longer available, so I'll just brief on the structure. We're going to be talking about the who, where, when, what kind of a situation about photography first. So that deals with, are we allowed to take photographs? Where are we allowed to take photographs? Are there any restrictions to taking photographs? So basically, it deals with issues of privacy, it deals with censorship, etc. Then we are going to be talking a bit about copyright, because I think that's one major gray area, and an area which photographers have a lot of interest in. So I would basically hand over the floor first to Apar to give us a brief introduction into the aspect of who can photograph, where can we photograph, and how is it in India and the Indian legal system, how does it work over here? Apar?
Thank you, Abhinav, for that introduction, and Delhi Photo Festival for giving me an opportunity to talk to photographers. Usually when photographers see lawyers, they're exiting a court, proclaiming a victory or hiding a loss. So this kind of interaction is unique, and I think so it should go forward, because in a lot of circumstances, photographers become aware of law as a reactive measure when they are limited in terms of taking a picture, or when they notice a picture which they have taken has been stolen by someone else. So the first aspect which I'm dealing with right now is with respect to your ability for creation. It's your ability to take a picture at a public place or even in a private premise. So firstly, this deals with the law of privacy, which generally gets a very low sanctity under law by itself. As Indians, we know that we ask deeply personal questions to each other the minute we are introduced. Where do you work? Right? Are you seeing someone? No. Okay. So essentially, Indian law of privacy does not exist. It is defined by its absence. And in terms of your ability to take pictures in, let's say, any public place, a road is unlimited. However, there are certain intersections which you notice happen every now and then, where a police official or a public guard tells you you cannot take a picture. And you also notice this happens the minute your camera lenses become a little larger, when your equipment becomes a little more elaborate, right? And I would say that these kind of interactions with law are not essentially clear. A lot of times they are based on prejudices as to national security or protection of women. And I would say that despite there not being no law with respect to privacy, which gives clarity with this respect, you have to negotiate individually. The second thing is, with respect to private premises, your access is limited and conditioned, and there is an expectation of privacy in private premises. Hence, you may be in breach of law if you take a picture there without permission. Secondly, you also need to consider taking pictures at special public spaces, such as, for instance, ASI protected monuments, where you are generally allowed under the specific rules of a law to take pictures, but have to take permission from the Director General of the ASI if you're putting up a tripod. And just because you're not stopped from taking a picture at one monument does not mean that rule does not exist. Because we realize that in India, rules are applied subjectively and based a lot of times on appearance. So it may differ from the day to day, from the day you have shaved, from the day you have a full beard, right? These are certain practical considerations which need to be considered. So also in terms of railway stations, so you can take a picture at a railway station, but if you're a foreign national who is taking a picture at a railway station, you need to have special permission from the Ministry of External Affairs. And I doubt many people have taken that permission, okay? And with regard to aircrafts and taking pictures inside aircrafts, there's a general prohibition where you can take pictures inside civilian aerodomes, but military aerodomes is completely prohibited. This is all clearly flowing from law. So when your interactions with law do occur, you will a lot of times be negotiating with people, and it's good to have a certain sense of knowledge about the law. And towards that, I think it was even mentioned and discussed with me and Abhinav that we are putting together a small handbook which may give you a broad overview of these distinct aspects and which may allow you to have a better negotiation. And we would solicit any specific queries which you face with respect to law, because we don't want to make it a book or a legal hardbound kind of thing. We want to make a handbook. Now, with respect to the content restrictions, I think let's turn it over. Yeah.
I just want to, since Apar mentioned the handbook, I thought I'll keep housekeeping announcements for later. Actually, this was an idea that was floated between Apar and me, that we'll try and create a document that sort of sums up what we are talking about here in a more succinct and sort of a better way. However, that we didn't have enough time to put it together and have the resources available to have it completely ready by this time around. So I opened the floor. At the end of the session, we'll give an email address out. It'll be interesting to get questions from you so that we can try and understand if we've covered every aspect or are there things that have been left out. See, because there are no clear-cut laws which regulate photography. There are a host of laws that regulate different aspects of photography. So it'll be a cumbersome exercise to go through every act possible to try and figure out how it intersects with photography. But if there are specific queries that come our way, we'll be slightly better abreast with what we need to deal with and how we can deal with it best. Also, we are also short of resources normally. So if anybody wants to volunteer to help us sort of put this together, that would be a great help. Otherwise, we'd still be doing it. It'll just take a little more time. So those announcements were for later, but I thought that I'll bring them up now.
Yeah, so I think so a large part of the restrictions were also with respect to when you're taking pictures as to certain themes which touch upon content controls in terms of pornography, photography of women who have been victims of sexual crimes. So for that, I think so I'll turn it over to Arundhati, and then from Sefi we'll bring it back to copyright. Okay?
Thanks, Apar. I think most of us are fortunate that we don't have too many interactions with the criminal law apparatus in our day-to-day lives, which is something which I would hope it stays that way, because when the state machinery comes at you, sometimes you don't know what's hit you. And especially if you are a photographer or photojournalist in a war-torn area, in a place where there's essentially a state of emergency, whether we acknowledge it or not, it can be very difficult as an individual, or even when you have a media house backing you, to actually deal with that situation on the ground. So what I thought I would do is just give you a broad sort of overview of the kinds of acts which are criminalized, which might affect photographers. As Apar had said earlier, one factor which does come up is that there's no specific statute which deals with photographs per se. So unlike, for example, film or the print media, when you're just looking at a photograph, then there's no one statute which you have to go from, which essentially means that the prosecuting agency could come at you from any number of places. And I'm going to elaborate on that in a minute. But I think the broad overview which I would give at this point is one, so therefore there's no single governing statute. Secondly, then, what criminal law actually regulates is both public spaces as also speech. And photography falls into a kind of intersection of both of these areas, where there are many statutes, including things like the Official Secrets Act, which regulate what you can or cannot record in a public space. And also then a gamut of laws which of course regulate speech, from, as Apar pointed out, the Indecent Representation of Women Act, to a host of other statutes which I'll get into now. So when we're looking at what kind of criminal law statutes there are, your subject areas are as broad as the Copyright Act, which criminalizes certain kinds of copying, to the Information Technology Act, which would then look at digital photography. There are punishments for violation of privacy. And what's really interesting about the IT Act is that it doesn't look at privacy in terms of a space where you're entering into someone's personal physical space and violating that, but actually a photograph of private areas which are body areas. So genitals, pubic areas, buttocks, breasts for women. So the definition of what is a private area and public area is not a spatial definition, but actually a definition of the human body. There are offenses for transmitting obscene material in electronic form, specific offenses relating to children under the IT Act, photographs of children. I understand that these are issues which can potentially come up in situations even like this, for example, where we are exhibiting people's creative work, and there's all kinds of reactions which may or may not come from different parts of the public. So like I said, the Information Technology Act is another statute. The Official Secrets Act is an example of a statute which has restrictions on what kind of public spaces you can photograph in terms of what the state thinks are highly sensitive or military areas on which there is therefore a ban, and on photography. And when especially there's an added layer of political pressure, politicization of an issue, of a space, then with OS Act publications, prosecutions, for example, what we've seen is it's extremely hard to get out of, because there's a single question of whether there's an effect on national security, or whether there's a safety or a spying issue involved, which itself lends a layer of prejudice against whoever may be the accused, or the photographer in this case. in such cases. The last thing which I'd like to just put out there for this part of this panel is that the Protection of Children from Sexual Offences Act, which was introduced in 2012, has a mandatory reporting procedure which imposes an obligation on media and studios which provide photographic facilities to report cases where they find photographs have been taken of children in sexually photographs which show that children have been used in certain offenses in acts which constitute offenses under that act. There's also a punishment for failure to report. So these are actually the newer areas which are emerging where photographers and studios are specifically being, there's certain specific obligations which are being imposed on your line of practice. And I think I'll leave it at that for the time.
Could you sort of elaborate a little on the compulsory, under the statute where you have to report any clear definition of what constitutes material that needs to be reported? Is there any clarity with that?
So the Act actually sets out in great detail what are the offences which can be committed against children. Essentially, it covers all kinds of sexual acts which a person could commit with a child in fair detail, and also child pornography and so on. So the mandatory reporting procedure works in the sense that if you were working in a photographic studio and you came across these photographs, then you are duty bound to report that to the there's a special juvenile unit which is set up to govern these, to investigate into offences under the Act.
Yes, please.
Thank you for the introduction. I'm sorry to spoil the party here, but I think that everything that that was discussed until now has nothing to do with the majority of the people that are attending this festival. Although all true and important subjects, they really have nothing to do with the day-to-day interactions that us as photographers have with our work, with the subjects that is the center of our photographic exploration, and is very theoretical. Might be more interesting for lawyers who get into the subject of intellectual property, but I doubt that it really catches the attention. I mean, I try to listen, and I'm very much interested in intellectual property, but I'm kind of like losing you in the cloud. And I think that what touches more closely to the lives of every photographer and everyone who's been taking pictures, not only in India, but everywhere in the world, but in India especially, because there's very little awareness, is the subject of copyright and moral rights and versus usage rights. And I think that with all due respect, and it's a personal feeling, I think that if we focus more on that, it would be
absolutely.
slightly more
the
beneficial.
idea was to broadly just categorize, starting with the concept of where and when can we photograph, and there is a large amount of gray area as far as that is concerned. If you look at France, that has pretty much prohibited street photography in a lot of ways, in terms of how they've structured their privacy laws. And being a gray area in India, there are a host of statutes that could potentially lead to criminal charges and investigations. So this was an attempt to basically show that every time you photograph, there are certain risks that you expose yourself to. You just need to be aware of these. Of course, you're not going to be knowing exactly who, what, when, where these risks are and how they can sort of come and attack. But every time you lift up the camera, whether in a public space or in a private space, there are potential laws that are attracted. So it's not as simple as just picking up a camera and shooting. There is, and Ishan wants to add something.
I had a question.
Yes.
Since we're talking about where law interacts with photography, yeah, maybe I should do that. With the Delhi rape case, the father of the victim at some point gave an interview, and there was a lot of pressure on photographers to get some photographs of this man. Now, what we were also told at the same time was that it's illegal to print a photograph or use an image of the victim or the family. But what happens when the survivor or the family decide that they would like to use the image, or they would like you to use the image because they feel that it has more value, etc.? Is that a gray area or is it black and white? Just a question, I mean, since we're talking about it.
So the law prohibits disclosure of the identity of a rape survivor.
Right.
There are some differences which have been brought in recently with respect to children, in cases where a court which is dealing with sexual offences against children feels that it may be in the interest of the child for that to be lifted. But broadly,
minors apart.
So minors apart. So essentially, as of now, I don't think that is something which has been litigated, because I don't think in this country you really see cases of victims coming forward easily to saying that they to say that they want their identities disclosed. I think also with media houses, even if the victim is, or the survivor rather, is ready to disclose her identity, the media house may not be comfortable in taking on the responsibility of facing a prosecution later.
Just to add to that, definitely I feel the practical aspect of photography is more often with its application with regard to its protection and how it's exploited, and I completely agree with Sefi, and we'll just be coming to that. For this question, I think so, I'll just add that in terms of a prohibition under law, if there's a criminal prohibition under law, you just cannot privately agree between you and the person that, okay, my daughter is no longer alive, there's no prejudice to her. You cannot make these private negotiations and just escape out of a criminal sanction. The mere fact that a criminal sanction is not resulting from you publishing it does not mean it does not exist on the book, right, and does not mean that it may not be applied. Yeah. So that's what we are trying to say.
So, Sefi, I think we can delve into issues of copyright. So, why don't you sort of give a brief background into, how you got embroiled?
Thank you. Just another layer on top of everything that was touched until now. Everyone who takes pictures in India have encountered these situations where you just want to go into some backyard in Calcutta and shoot some standing relic. The chowkidar would come and say, no, and we either deal with it or we don't deal with it. I don't think that anyone has encountered a lawsuit coming out of any of these situations. So until something like that happens, I don't think that this would ever jump into the attention of the touching points between photography and law.
No, but you often do find your equipment being confiscated, which does come.
Do you know of anyone specific?
Yes, absolutely.
Yeah, okay, so
yeah, a lot of people have the equipment taken away. I mean, confiscated is a slightly formal word in that sense, but it's just grabbed essentially. Now, is there a law to do that? No, of course not.
I might have been just lucky then.
I think you're lucky.
Okay.
No, and actually, the law does provide for confiscation of materials which are violating. So books, photographs, any kind of publication.
No, we're talking about cameras here, not.
And also, I would therefore imagine that. So I don't want to get too technical, but given that there's a copy of your photograph which exists on your camera, I think there's lots of actually ways in which your materials, your cameras could be confiscated, and specific statutory provisions. I think I'm just going to make one point, okay, which is that I would certainly hope that nobody faces criminal prosecution. It's good for me, but it's not good for anyone else. But what we find is that in cases where people are doing politically sensitive beats, or something like the Helka, the 2G case, these are cases where not photographs perhaps per se, but media and journalists have found that work that they have done has resulted in criminal prosecutions, including against them. So I think the problem is that we kind of exist in a vacuum as far as criminal law is concerned, that sometimes there's a prosecution, and it's very scary to suddenly be facing arrest, to be inside jail, and also for the entire state machinery to be against you, especially when you are doing politically sensitive work. So I think these are the situations in which it becomes especially important to at least make yourself aware of what's out there. That's it.
That's why we're going to use lawyers to protect us. No, but I think that today the major problem or the major issues that photographers are using is copyright and image theft. You know, because everyone who has any of his images on the social media, on Facebook or a website, you know, has probably encountered his images being stolen and reused. But not only that, I think that in terms of the law in India, in terms of the copyright and the practice, the general practice in India, I strongly feel that the common practice or the standard is a copyright violation. That is the starting point. It's not the law that comes first. It's the non-law, because I find it a lot with a lot of people that write to me with asking for advice, and a lot of journalists, young journalists especially, you know, whose work has been published without credit, without pay, images stolen. This is the general practice. And this is probably because the Indian law system has been perceived as very slow and ineffective, and that is where, you know, we have to focus. I mean, if we want to make any kind of change, it would be one in educating people in terms of what is their right, you know, and what copyright means and what it is that they sell in the image. So that they are not exploited by the corporates and the newspapers and magazines. And second is what to do in case you are exploited, in case of an image theft. And this has degrees, of course, you know, whether it's just someone lifting your image on Facebook and removing the watermark and using it again. What are you going to do? And what are you going to do if someone takes your work of 5 years and claims that it's their work? So that it has to be some kind of an education system for photographers to know
what I'm interested in knowing is, as a lawyer, as a photographer, what do you do before you actually talk to a lawyer a lot of times? Because you do have a valid copyright for your image, but the legal system is certainly not one of the most efficient ways to go about enforcing your right, and you realize that, right? How does one go about it?
Well, first of all, you have to know that what is rightfully yours.
Yes.
So you have to know at least the basics of the law, so that you could act upon, keeping your rights, knowing what is the difference between copyright and usage rights. Yes. First of all.
So I think that would basically take you to the fact that you need to keep a track of where your content is and how it's flowing. I think that would be the starting point.
That is, I think, very difficult to keep track of that, especially now that you have your images on so many different websites and so many different platforms. You cannot keep track of where it is. You should know what is yours, and once you put your work out there, what is legal, what is proper usage, and what is not. Now, what is true in India would probably be true everywhere else in the world. You don't want to get into legal action. You don't want to get into the court system, regardless if it's an effective system or if it's ineffective system, because you never know what the outcome is going to be. In any case, it's going to be long, and it's never over until the fat lady sings. So I think the first thing that you should adopt is just either Google it or find through a friend. There's a very simple first step that you must know how to take, which is a cease and desist or a letter, a very simple, properly structured letter in a legal language that would say, "I dare you not to remove that image from wherever it is. And if you don't, I keep all the rights to your image." And it's a very mathematical way to do it. Every lawyer would know it. A cease and desist. Stop right now. Promise that you're never going to use it anymore, or else. I find that it works in 99.99% of the times. So that saves a lot of time. if at all you even want to get into this. Many times you just want to, if you have a lot of images out there, you probably need to have someone full time just to handle these cases. But a seasoned deceased letter usually does the job. And when you talk about major cases, I mean, if it's a really huge copyright violation, then you're forced to go to court, and that's why the courts are there. And I think that it's our obligation to pursue, to find the justice, so that others would know. But that's of course the last resort. I mean, only if you're pushed to the corner, of course.
Another thing, Safi, before I sort of just lay out certain basics of copyright law, what has your experience been personally? Of course, I'm not asking you to comment on specifics, but when you do enforce your copyright, is it viable for everyone to do it? When you're forced to go to court, even then?
I'm afraid that the answer would probably be no.
Okay.
And because it's a no, and the no is because it takes a long time and it takes a lot of money. But this situation is exploited by the people who violate the copyrights on a regular basis. Let's say Times of India have taken your picture, one picture, and published it, and they haven't paid you and they haven't given you credit. They just stole it off of you and they published it. There's so many cases. I'm sorry if I'm just saying Times of India, but they must have done it so many times, and they're not the only ones. And they count on the fact that you're not going to do anything because you don't have the resources and you don't have the time to invest in that. But every now and then, we should pick some giant that we're going to slaughter and fight it all the way.
Yes.
And the few of us that have the means and have the ability should do it. I'm now I've been in the last 5 years in the middle of a big case in the High Court. It's costing me a fortune and it's taken a long time. But the the publisher who has violated not only my copyright but the moral right of the work has really been surprised that I'm not letting go. Because this was like they were sure that I'm probably not going to do it, because really it's going to involve so much time, so much money, and I feel that every now and then a case like this has to come to the knowledge of photographers and knowledge of the fraternity and act as a deterrent, So that, but the thing is that I'm lucky to have just somehow made a break into an area of photography that enables me to earn enough money to pursue something like this, and I'm represented by an office that doesn't insist that I pay all the bills right now, and I hope that it would set a certain kind of an example. But the market must change because India.
I think we have a question from Krishan.
I just recently experienced a copyright violation of my image, and sorry, I'm bringing a question because I feel it's pertinent. What about the people who've been cheated or treated as pushovers by these so-called corporates? And we're very frustrated, but maybe a lot of us can't afford to take it all the way through. So what about those sort of people? Frustrated, want to take it through, but can't afford to take it through. Some sort of insight into that, please.
Well, should I say that? I mean, in most cases, you're just going to have to live with it. No. Listen, this is the reality. It's not a happy reality, but it is the reality, because if it's a once in a or if it's a one image, there's no way that you will be compensated for your time and the effort of pursuing it. So really the only thing that you can do is a cease and desist letter. That means stop right now, or else. You just and if it's presented in a legal way, it's a very scary letter. I have one that is really, really scary, and I add to whoever is violating my rights that if you insist, I'm going to put my lawyers on that, and they will empty your saving box from the time that you were 5 years old. So if you're scary, most of the time, seriously, 99.9% of the time it works. I've managed to get payment in thousands of pounds out of copyright violators outside of India with just email correspondence. Sorry? I hope that next year I will tell you yes.
No, but that goes back to everything that we have in our lives. We have the rights. Okay, if we don't enforce it, then you're just letting people walk over your rights. So first of all, you need to be aware of what your rights are. Till you're not aware of what your rights are, you're not going to be able to protect them. So the first step is to educate yourself as to what your rights are. Everything else is secondary. Whether you go after them or you don't, everything is secondary. And before we sort of get into the questions, I just wanted Apar to make a brief presentation on what copyright really is and how it affects photography. So I'm going to just give the floor to Apar for a bit, and then we'll get into a greater discussion.
So I'll just limit myself to 5 minutes, and I'll draw out the basics of copyright law. In case you're interested, over and above of what I'm saying, is that the government has put out a very good Q&A handbook on copyright laws. The government does do good sometimes, and this is one of it. Okay, so please go through it. It's on the website of the Copyright Office itself. As Sefi broke it down for us, so he first said that you should know what copyright is. Secondly, is the part he talked about enforcement. So let's just look at the first part. When does copyright come into existence? Well, it's quite simple, as so many people just say, "Aap to bas button dabate ho." So that's the same method by which the copyright comes into existence, by you pushing a button. That is it. Because copyright is a limited monopoly. It is a protection which is given to any artist, and it is not so as to say so much interested as to any elaborate process by which you are constructing models or setting up elaborate sets to take a picture, as much as your artistic decision. And it's concerned with a very low level of artistic decision. So each time you take a picture, you're deciding what's the aperture, even if it's done by software, what's the angle, you're holding it up, and you're deciding what's the lighting, etc. These are all creative decisions. Even if I take a picture by my camera phone, sitting right here like this, copyright has come into existence. You do not need to register copyright. However, certain people do register copyrights because it creates a presumption that they are the owner. It's just like me staying in a house and knowing I'm the owner, but at the same time also having a title property to that property. So that's what a copyright registration is. But under copyright, you do not need to have those papers to go to court. Okay, those papers only will make your case that much more better, that you are the creator of that copyright. A lot of times you work on assignment, you do work for hire, for instance, wedding photography, right? And who owns the copyright to it? A lot, in most of these cases where control and supervision is not exercised over you, where people are not minutely monitoring the details of your assignment, you are the author as well as the owner of the copyright. And when control is substantially exercised over you, for instance, you are a photojournalist and your editor is asking you to go to, let's say, Jantar Mantar and take a very specific picture of a specific politician, then they are the owner, but you are still the author of the work. So in any case, you are the author of the work if you are working for someone else. So what this means, you have moral rights. As what? Yes. Okay, I'll just touch upon that. So Sefi's just written waiver only in writing. So I'll just come to that. What I'm telling is right now the basics, right? So yeah. Okay. So especially in cases, you know, when you're taking, so your moral rights, as he was talking about, what are moral rights? Moral rights, your assertion to be identified as the photographer who took this image. Now, let's come a little further in terms of cease and desist and how do you enforce your rights. So Sefi was mentioning a cease and desist letter. It's actually up on his blog, and he's made a very helpful template. And as a lawyer, I find it to be very well drafted. You can probably use it. What it does, it sets out certain basics. It first identifies you as the person who owns the work, who's the owner of the work, because that's what you're concerned with in a lot of circumstances. You're freelance photographers, you have taken that picture by yourself. So not only are you the author, but you're the owner of that photograph. So it identifies you. I am the owner, I am the author. The second part is, you have taken this picture without my permission. Because what is copyright giving you? It is giving you certain rights to make copies, to authorize how it is used, to, in fact, if it is used by another person, under what conditions will it be used? Whether it will be used for free, whether it will be used for payment of money. But in any case, in any kind of display of your work, you have to be identified as the photographer of that picture, right? So that is the second part. And the third part is asking that person to remove that image, okay? Of course, he's talked about the court system and how it's slothful, it's glacial, and it works at its own pace, but that's the same in a lot of other jurisdictions. However, what's different amongst Indian defendants, media houses, and people who infringe your work, as opposed to what is different outside, is that the costs are are structured in such a way that there are greater disincentives onto parties who infringe. They also engage lawyers who are very expensive, but at the same time they know if they lose the case, your attorney costs will be imposed onto them. And there are other things as well. So they rather settle than drag this out. Moreover, in the Indian court system, you can drag things out much more easily. And there are legitimate concerns with regard to access to justice, because, you know, if you go to the Delhi High Court, because you need to value every case you make in court in terms of a copyright infringement. I'm not talking about the criminal remedies. I'm talking about the civil remedies. That's what's even in issue in Sefi's case. So you need to value your case. The minimum jurisdiction for the Delhi High Court is 20 lakhs. So you say my picture is worth, my photograph is worth 20 lakhs, you used it without my permission. So at the very first instance, when you file your case, you need to pay 4% court fees on 20 lakhs, which is about 80,000. Then you need to pay money, 4 rupees per document. Vakalatnama is about, but you don't have to value it there, but it's, you know, what's the practice? In terms of injunctions, yeah.
It's expensive.
It's expensive, but you know, things are moving at a certain pace still, as compared to district courts.
And there are ways to shorten the procedures.
Yes, there are ways to shorten the procedures, but coming back to the point, it is expensive, it is drawn out. So a cease and desist letter would probably be a lot of times a more efficient outcome as opposed to approaching court, because it would stop a repeated infringement of your work, but it would not, in a sense, give you money. So that's the realization, that's the practical realization we all have to live with. So with that, I'll just
So if I had to sort of bring it down really layman language from, if you're employed by an organization as a photographer, they provide you with an equipment, but your employment contract is silent on the issue of who shall own the works produced by the photographer. What would be the status of such case?
Merely because somebody is providing you equipment does not mean under the Act, the copyright law that we work in, that they are exercising supervision and control. So I just to give you 2 examples. You as a photojournalist, you as a wedding photographer, okay? And the thing is that a lot of times, because there is not much clarity, they make you also sign a supplemental waiver that you are not the author or owner of that work, and they also make you sign assignment agreements a lot of times. They make you do that. But if you're under a regular employment contract, a lot of times it will naturally be going back to the media house for whom you're working. So even though you can assert your moral rights that this is the person, I took this picture, the author, so there's a differentiation between the author, photographer, and the owner here, and the owner would be the magazine or the media house, and the author would be you. So that's broadly.
A few things to add. Yeah, I mentioned copyright will remain with the photographer unless the other way, unless given up in writing. So unless you actually signed an agreement that says, I give you the copyright. This is the only way that you can give up your copyright, in writing. Any other way, copyright will stay with you. One more thing to add about moral rights. There are three terms that you need to remember in terms of the copyright law and protecting your rights and your images. There's copyright, there's moral right, and there's usage rights. Assuming that your client understands that the copyrights is with you, when you sell an image, let's say you've taken an image and some client comes to you and says, I'll pay you $1 million to use this image as a billboard on the New Jersey Turnpike. And he pays you the $1 million, and the next week you see that this picture is also printed in the corporate, in their corporate identity or whatever, they violate your copyright. So when you sell an image, especially from an archive, but not only, but when you sell an image, you have to make sure that your contract defines what the image is going to be used for, and any extra usage in that image without permission violates your copyrights. So let's say you're a wedding photographer, and you allow your client, you say you own the images. Like that means that they own the personal usage rights. They can print, they can share, but they cannot sell the image, and they cannot make a profit. So all these things need to be identified in the contract. I will not get into the dry information about that, but usage rights is what you sell, copyrights is what you keep. Now, in terms of the copyright, we also have the moral rights, which Apar had mentioned before. And moral right doesn't only mean to be recognized as the author of the work, but there's also the right so that your work is not mutilized. Yes. Mutilization of your work. Let's say you're a sculptor and you sold your piece of art to a certain corporate, and it was under certain agreement, and then the next day you come and you find that they painted it yellow. So that you sold the sculpture, but the copyright is yours. It's your sculpture, so they cannot go and paint it yellow. What happens to me, and I'll just mention in a word, because it's mutilization is a very, very elaborate subject. There could be so many ways that a work can be mutilized. I had an agreement with the publisher to publish a book of my photographs. The agreement specified the copyright. The publisher had one-sidedly decided that they're going to take a couple of images out of the collection. Not only that, the agreement mentioned that the entire compilation of images as laid out in the book are defined as the final work. So I have copyright in the entire collection. They took out a couple of images and included extra recipes, moved certain parts of the book to the front, and the book went out with my pictures, with my name on it, but instead of being in the photography section, it now shows in the food section. So that is mutilization of my work. They used copyrighted material, which they agreed to be copyrighted, and then mutilized it. So you are entitled to have your work presented the way that you envisioned it. Selling usage rights does not mean that whoever is using your images can now decide that they're going to cut out the face of whoever is there and then use it in another work. So this also falls under moral right, your right to be identified as the author, but also so that your work is not mutilized by the user.
And this applies to commissioned work as well.
It applies to anything. Now one more thing about Indian law that is not like in other places. In India, and this is not so good for photographers and artists in general. You have to prove damages. Which then, I mean, even if you win a case, you have to prove the kind of damage that you've suffered, and that becomes a very tricky thing. So,
no, on the subject of mutilation, because we are all artists in some way or the other, and we are all sort of trying to create newer work, and we sometimes take inspiration from other people's work. Sometimes we create collages based on older photographs, etc. It is a kind of mutilation in some ways. So for people who are indulging in artist work which uses other people's images and creates a third property altogether, what is the procedure to go about it? Like, can you just elaborate a little on that?
I would say it's really tricky because most of the times and see, the thing is our ease with utilizing content and making mixed media kind of content has become that much easier with technology and tools on a laptop. So we don't realize what are the underlying legal protections, and it applies to as much as content we use already, as much to our work. So let's recognize a lot of times in terms of picking up others' work, we may be infringing upon their copyright, and it is done quite often. So for instance, if you take a picture and even if you put it through a high level of, let's say, digital alteration through some tools, okay, but it's still the same work, it's derivative, you haven't taken permission. But if you kind of transform that, it's not meaning to say you independently go out and take a picture, but if it's completely a different work, then no. Secondly, what I'll also say is that a lot of times it's just much more easier, especially in bigger companies abroad. I have noticed they just license whatever they need in terms of making anything mixed media, or go, and even if you're a small organization, they go by work which is licensed on copyleft licenses, which we see quite often now, but the artist has given you permission, the photographer has given you permission. So for instance, on the Flickr platform, you'll notice a lot of CC license, which specify terms of licenses. In certain licenses, you can't use it for commercial use. In certain licenses, you can use it for commercial use. And so that would be my recommendation. If you're trying to closely abide by the law, just make it less complicated, because getting a sense out of copyright without it going through a process of litigation is sometimes very different. And at most, lawyers can flag risk and liability for you and the potential for that. But if you just want to keep things cleaner, I would suggest you go by taking permissions. It also adds to your reputation slowly, right? You as an artist yourself, if you infringe, that doesn't speak well about you. So socially, it does make sense.
So basically, pay for what you use. In a nutshell, just pay for what you use, you're safer. And I think Arundhati just wanted to add something.
Yeah, I just want to add something on what we've been saying about costs of going to court. I think one thing to keep in mind about criminal law is also the cases when you can use it. So it's much cheaper actually to go to court to prosecute yourself, to go against someone in a criminal case, because you don't have issues of valuation, like you do in a civil matter, where, as Apar was saying, you have to show what the worth of your work was, whether it's 20 lakhs and above and so on. And if you have not been recognized as the author of your work, and if your reputation as a professional is impinged upon, then you would have a remedy in defamation to say that I'm defamed by not being recognized as the author of my work, or having authorship of something which is not actually mine, like the example you give of the yellow yellow artwork. So that is a criminal law remedy which you might have, and which is also quite effective, because when you act against a company, in particular, if you can show specific liability of specific decisions which are taken by an individual editor or owner of the company, and if you can trace back well enough to identify specific things which are done, not just by a name, company X, but also by individuals who are there, then criminal law remedies are very effective.
Ownership basically allows commercial exploitation. Okay, as an author, you have moral rights. So you're the author of the work. So basically, you have the right to have that work be identified to you. But commercial exploitation of that work is no longer with you, it's with the owner. That is the whole concept of ownership. When you own something, you can further sell it. But if you don't own it, then the commercial usage of the work becomes that much more difficult.
Practically, if you see a lot of compilations which are made by artists or writers where they have written for other publications or media houses, not in terms of employment, but where they have been commissioned writers or columnists or photographers, they seek permissions, and it's given on the first 2 pages where the copyrights are recognized of that publication house, even though the author is the person who's brought out that book, because at that time he wrote it for that publication house. And usually, it happens in terms of a biographical publication, which is permitted a lot of times in terms of industry practice. At worst, what may happen, they may demand a certain amount of payment from you, for which may be a license may be entered between you, and it does seem counterintuitive, because hey, you started out, you took these pictures, right? And why should you now take permission from somebody else and give them a part of the money for your work, right? But you were paid when you took these pictures as well, right? So.
But in the absence of a written agreement.
No, but in the
90% actually, 90%.
So the absence of a written agreement in the sense of you working for someone, or the absence of a written agreement?
A photographer is working for a company.
Yes.
But nothing is written in the contract about the copyright.
Yes.
Who owns the images or right? So ultimately, so who owns?
That would naturally arise to you, because a written contract is one of the circumstances which do evidence that you are under direction, control, and employment of another person. So I would say an absence of a written contract would certainly, arise a presumption that you're not only the author, but you're also the owner, even though that informal interaction may be to the contrary.
But if the company is able to prove actually that you're under employment as an employee, then in that case the ownership vests with the company. It goes, because our laws are predated, it used to work on film earlier. So what the company used to own is the film, and based on owning the film, it would own everything inside that film roll, which is the copyright. So because they owned the film when they used to give it to their employees to go out and shoot, etc., once they owned the film, they owned the copyright to those images because they were contained in that film. The law hasn't really caught up with, the digital age and the concept of censors, etc. So if the company does prove you to be...
I have to defer that. There is an amendment to the law in India, and it's not anymore according to who owns the negative. So
No, it doesn't. I'm saying the concept. I'm sort of taking back that concept. But if you are an employee, then essentially the work that you're producing, you're the author, but the company is the owner, and that there is no sort of there's no gray area as far as that is concerned. No, see, commissioning is a very different area. That's purely contractual. Employment is not purely contractual in that sense. Employment has certain other things embedded into it. Whereas when you're a freelancer and you're commissioned work, then all those things need to be taken care of. And if it's silent, then the presumption is in your favor.
There are a lot of cases, if you work with UN officers, the contract of assignment would determine that they own the copyright in your images. So it has to be in the contract, otherwise it's yours.
Hi, I just have a quick question about the right of the subject. Because a lot of times we have, we get waiver forms signed or no objections, but sometimes we don't, especially when working independently. And subjects could have problems with representation sometimes. So in that case, how does copyright play a role?
So copyright does not have a role there. What may have a role, I think so, maybe distinct branches of tort law, which can be made up in terms of civil law. In terms of criminal, I think defamation may be an issue, but it can be mitigated to a large extent by a waiver form, and to what extent it's permitting you to take those pictures. So if your waiver form, for instance, states that this is an artistic photo shoot in which the model will be requested to make certain movements or place themselves in certain manner and form, which are up to the discretion of the photographer, and the model understands that such representation will be open to the creative decisions of the photographer, it will be tough for that model to later go on and argue something against you, because this is not copyright, this is privacy, right? And it's just a good practice to have that waiver form in.
If I can add to that, it's called model release on property release. You can just Google model release, you'll have a zillion samples. It's a very simple thing. The model releases, and that's it. Unless you have a model release, there would be a lot of publications that you would not be able to use. Any commercial use, any. Yeah, and then it's a completely different thing. You know, the any commercial use must have a model release. Any editorial use does not need any release from anyone. You can publish the work in a magazine. You can publish it on your website. You don't need any release. But it also extends in terms of the release. There's a model release. There's a property release. There are a lot of, but that's a very different field.
One last question.
Hi, my question is slightly different. It's not relating to copyright. I am from Bangalore and I'm a co-founder of a newly formed art gallery. So my question is regarding to the law to exhibitors. Is there a specific law that stands in India? My question is that, I mean, we've approached by an artist or a photographer. And if there is a copyright case put on him on some particular image that has been showcased in a particular gallery space, is there a law, is there a rule that's, you know, that can bring the gallery
so very quickly, what happens here is that you will also be made a defendant in this copyright case because you have the deep pockets. The artist, unfortunately, a lot of times may not have that amount of money which a gallery may have. So you may be made a defendant. However, at the second time, you are essentially exhibiting a work based on certain representations, where the artist has stated they are the lawful owner of the work. So in such kind of circumstances, you shouldn't fear copyright infringement. So you should ideally have a contract with that artist, which I think so you may be already having, that your work will be displayed from this time to this time, and etc., which also has one legal clause, which is called the indemnity clause, that based on the representations of party A, if damage occurs to party B, then all the risk, consequence, and expense which flows from the fault of A, which is placed on B, will be reimbursed by A. So that's, yeah, but practically such indemnity clauses don't work out the best. So
have you experienced, any of you have experienced any such case in India where, you know, due to an artist who has a copyright problem or any kind of issue?
Firstly, copyright infringement litigation by itself is a very minuscule part of intellectual property litigation, which is concentrated on trademarks. And copyright litigation, when it does occur, targets the person who's infringed. If there are other parties involved, most of them are now internet intermediaries or something. They get out of it by saying that we had no role, we had no knowledge, etc., and they try to get out of the case. But most litigation is towards getting an injunction, towards stopping you from exhibiting that work, after which the parties come together, the principal defendant, which is the artist which is infringed, and the artist which actually has the copyright, or at least has got the injunction, they settle, and then the case ends. Because nobody in today's day and age, there are parties like Sefi probably who have the patience and probably the stamina for litigation, but a lot of people after the injunction, after you stopped someone in let's say about 6 months or something, they don't have the financial capacity or the stamina to carry it through.
I'm just going to add one more thing actually. That doesn't apply for criminal liability. Suppose you're showcasing pictures which are found to be obscene, okay? Or hurting religious sentiments, which is I think another big problem.
That's another thing that goes on.
Yeah, so those are cases where if there's a criminal case against you, you would probably also be made a party as the person who showcases the work. And that is not something which you can get out of easily by settling with the other side. So I know these are frequent problems which are faced. If the work is found to be obscene, if it's found to hurt religious sentiments, if it's found to be violative of national security, that's another area. But you would probably be facing liability, and it's not something which you can contract out of. So an indemnity clause would not protect you in such a case against criminal liability.
And one more thing that you need to know, that is recently the death penalty has come into force against gallery owners who exhibit the work of other artists, so it can happen.
So I think we can conclude over here. If there are any other questions, see, the evening slideshow is on, so whoever wants to leave, we can still hang around a little to sort of give out a few more answers if you have personal questions or something. just give your mail, just give your mail ID.
So my email ID is apargupta@gmail.com. So you can send everything so I and the NSA can read it together and respond. So it's, yeah, GUPTA. APAR So, yeah.
Any other questions, concerns? Otherwise, we can sort of disband. Well, thank you so much.
Right? These are certain practical considerations which need to be considered. So also in terms of railway stations, so you can take a picture at a railway station, but if you're a foreign national who is taking a picture at a railway station, you need to have special permission from the Ministry of External Affairs. And I doubt many people have taken that permission. Okay? And with regard to aircrafts and taking pictures inside aircrafts, there's a general prohibition where you can take pictures inside civilian aerodomes, but military aerodomes is completely prohibited. This is all clearly flowing from law. So when your interactions with law do occur, you will a lot of times be negotiating with people, and it's good to have a certain sense of knowledge about the law. And towards that, I think it was even mentioned and discussed with me and Abhinav that we are putting together a small handbook which may give you a broad overview of these distinct aspects and which may allow you to have a better negotiation. And we would solicit any specific queries which you face with respect to law, because we don't want to make it a book or a legal hardbound kind of thing. We want to make a handbook. Now, with respect to the content restrictions, I think let's turn it over. Yeah.
I just want to, since Apar mentioned the handbook, I thought I'll keep housekeeping announcements for later. Actually, this was an idea that was floated between Apar and me, that we'll try and create a document that sort of sums up what we are talking about here in a more succinct and sort of a better way. However, that we didn't have enough time to put it together and have the resources available to have it completely ready by this time around. So I opened the floor. At the end of the session, we'll give an email address out. It'll be interesting to get questions from you so that we can try and understand if we've covered every aspect, or are there things that have been left out. See, because there are no clear-cut laws which regulate photography. There are a host of laws that regulate different aspects of photography. So it'll be a cumbersome exercise to go through every act possible to try and figure out how it intersects with photography. But so I'll just do a brief introduction, and then we are going to be delving into a simplistic view of how law interacts with photography, because it's a very vast subject and it's going to be very difficult to capture everything, but we are trying to keep it as interactive as possible. So we are going to leave a lot of time actually for receiving your questions, and we have a panel over here which will try and answer the questions and situations that you faced. So my name is Abhinav Sanghi. I am a qualified lawyer to practice in India and the state of New York. I completed a master's from Columbia University, and thereafter I took a sabbatical to pursue photography. I went to formally study it at the International Center of Photography in the documentary photography and photojournalism program, and I've recently moved back to Delhi. I have with me Apar Gupta. He's a qualified lawyer to practice in India. He completed his master's also from Columbia Law School from New York and is a partner at Advani and Company. As a litigator, his practice is concentrated in civil and commercial disputes, which include arbitrations. A majority of his representations are for clients in the media and the telecommunications industry. He's authored a book on information technology, which has been published by LexisNexis, and he's a regular columnist for the Indian Express. There we have Arundhati Kadju. She's a criminal lawyer practicing in Delhi. She graduated from the coveted National Law School of India, University, Bangalore. She specializes in white-collar crimes, and in particular for CBI trials. We have Sefi Burgeson. Sefi is an Israeli-born photographer who has lived and worked in India since 2002. Previously a commercial photographer and the president of the Professional Photographers Association in Israel. His work in India revolves mainly around travel and culture, and he balances that out with photojournalism. He's an author of a blog called Photowala and is the owner of. If there are specific queries that come our way, we'll be slightly better abreast with what we need to deal with and how we can deal with it best. Also, we are also short of resources normally, so if anybody wants to volunteer to help us sort of put this together, that would be a great help. Otherwise, we'd still be doing it, it'll just take a little more time. So those announcements for later, but I thought that I'll bring them up now.
Yeah, so I think so a large part of the restrictions were also with respect to when you're taking pictures as to certain themes which touch upon content controls in terms of pornography, photography of women who have been victims of sexual crimes. So for that, I think so I'll turn it over to Arundhati, and then from Sefi we'll bring it back to copyright. Okay.
Thanks, Apar. I think most of us are fortunate that we don't have too many interactions with the criminal law apparatus in our day-to-day lives, which is something which I would hope it stays that way, because when the state machinery comes at you, sometimes you don't know what's hit you. And especially if you are a photographer or a photojournalist in a war-torn area, in a place where there's essentially a state of emergency, whether we acknowledge it or not, it can be very difficult as an individual, or even when you have a media house backing you, to actually deal with that situation on the ground. So what I thought I would do is just give you a broad sort of overview of the kinds of acts which are criminalized, which might affect photographers. As Apar had said earlier, one factor which does come up is that there's no specific statute which deals with photographs per se. So unlike, for example, film or the print media, when you're just looking at a photograph, then there's no one statute which you have to go from, which essentially means that the prosecuting agency could come at you from any number of places. And I'm going to elaborate on that in a minute. But I think the broad overview which I would give at this point is one, so therefore there's no single governing statute. Secondly, then, what criminal law actually regulates is both public space.
Dealing with right now is with respect to your ability for creation. It's your ability to take a picture at a public place or even in a private premise. So firstly, this deals with the law of privacy, which generally gets a very low sanctity under law by itself. As Indians, we know that we ask deeply personal questions to each other the minute we are introduced. Where do you work? Right? Are you seeing someone? No. Okay. So essentially, Indian law of privacy does not exist. It is defined by its absence. And in terms of your ability to take pictures in, let's say, any public place, a road, is unlimited. However, there are certain intersections which you notice happen every now and then, where a police official or a public guard tells you you cannot take a picture. And you also notice this happens the minute your camera lenses become a little larger, when your equipment becomes a little more elaborate, right? And I would say that these kind of interactions with law are not essentially clear. A lot of times they are based on prejudices as to national security or protection of women. And I would say that despite there being no law with respect to privacy, which gives clarity with this respect, you have to negotiate individually. The second thing is, with respect to private premises, your access is limited and conditioned, and there is an expectation of privacy in private premises. Hence, you may be in breach of law if you take a picture there without permission. Secondly, you also need to consider taking pictures at special public spaces, such as, for instance, ASI protected monuments, where you are generally allowed under the specific rules of a law to take pictures, but have to take permission from the Director General of the ASI if you're putting up a tripod. And just because you're not stopped from taking a picture at one monument does not mean that rule does not exist. Because we realize that in India, rules are applied subjectively and based a lot of times on appearance. So it may differ from the day to day, from the day you have shaved, from the day you have a full beard.
The digital nomad, organizing workshops and photographic expeditions in India. Cefi has been active in drawing photographers' awareness to copyright and moral rights, and is now embroiled in a major copyright violation case in the Delhi High Court. Then we have Ishan Tankha. Ishan is a Delhi-based photojournalist whose work has been featured in a number of publications, including South China, Morning Post, Le Monde, India Today, Guardian, BBC, Open Magazine. He graduated with a bachelor's degree in history in 2001 and is currently the photo editor for Tehelka. So without further ado, we were supposed to have a bit of a slide, but because of technical things, I had like the structure laid out, but it's no longer available, so I'll just brief on the structure. We're going to be talking about the who, where, when, what kind of a situation about photography first. So that deals with, are we allowed to take photographs? Where are we allowed to take photographs? Are there any restrictions to taking photographs? So basically, it deals with issues of privacy, it deals with censorship, etc. Then we are going to be talking a bit about copyright, because I think that's one major gray area and an area which photographers have a lot of interest in. So I would basically hand over the floor first to Apar to give us a brief introduction into the aspect of who can photograph, where can we photograph, and how is it in India and the Indian legal system, how does it work over here? Apar?
Thank you, Abhinav, for that introduction, and the Delhi Photo Festival for giving me an opportunity to talk to photographers. Usually when photographers see lawyers, they're exiting a court, proclaiming a victory or hiding a loss. So this kind of interaction is unique, and I think so it should go forward, because in a lot of circumstances, photographers become aware of law as a reactive measure when they are limited in terms of taking a picture, or when they notice a picture which they have taken has been stolen by someone else. So the first aspect which I'm